Hello, everyone, and thank you for joining ACS in the Law and Political Economy Project for Intro to Law and Political Economy 1. My name is Peggy Lee, and I am the Director of Chapters at the American Constitution Society. I am excited to welcome you to the first session of our joint ACS and LPE series on Law and Political Economy 101. After this event, we'll have 2 more sessions this semester, one on October 22nd and November 18th. I want to give a quick shout out and thank you to Amy Kepchinsky, Ganesh Sitaraman, Corinne Blaylock, and Sabeel Rahman and ACS staff for working tirelessly to bring this event together. We are so excited for this partnership, and there are so many people that work to put together this event, so just wanted to thank them all for their efforts. Really quickly, for those who may not know, the American Constitution Society is the nation's largest progressive legal network. ACS believes that the Constitution is of the people, by the people, and for the people. We interpret the Constitution based on its text and against the backdrop of history and lived experience. Through a diverse nationwide network of progressive lawyers, law students, judges, scholars, and many others, we work to uphold the Constitution in the 21st century by ensuring that law is a force for protecting our democracy and the public interest, and for improving people's lives. We are a 501c3 nonprofit organization, and we do not support political parties or candidates for public office. We're going through a difficult and troubling time. Justice Ginsburg is one of the greatest and most influential public servants in American history. The process to name her successor should be dignified, thorough, and fair. A Supreme Court vacancy has never been filled this close to an election, and the stakes are enormous. The Senate must not consider a nomination to fill the vacancy left by Justice Ginsburg's passing until after the inauguration of the next president on January 20, 2021. Virtual hearings for a lifetime appointment to the highest court of the land is just not an option. All circuit court nominees have appeared in person during the pandemic, and we can't make an exception when the stakes are this high for the American people with this Supreme Court nomination. We all have a stake in this fight, and our job as a community is building out and disseminating this constitutional case for the fight of our lives. ACS President Russ Feingold and many ACS leaders have written op-eds and letters to the editor on the importance of the courts and why the Senate shouldn't replace Justice Ginsburg until after the inauguration. They've connected the courts with the lived experiences of everyday people and highlighted the legacy that the courts will have for the next generation. We encourage you to also speak to your neighbors, your community, and write op-eds. If you have any questions on this, please reach out to us at campus@acslaw.org. Before we begin the event, I just want to give a quick update on other ACS events and opportunities to highlight. We are recruiting lawyers and law students for nonpartisan activities this election year to help make sure that we have a safe, fair, delay-free election for all voters. One opportunity is to monitor cyber voter suppression. So this year with COVID-19, election protection efforts are moving to kitchen tables and living rooms by helping monitor social media for misinformation and disinformation. With support from Common Cause staff, you'll assist voters with questions they post online, as well as correct misinformation and disinformation on major social media platforms. If you want to volunteer, please email lcemails@acslaw.org. For lawyers on the line, we also have an opportunity for you to volunteer with the Government Accountability Project through its Democracy Protection Initiative, which seeks to protect democracy by supporting employees who choose to blow the whistle on illegality and abuses of power aimed at undermining the election or sabotaging the peaceful transition of power. If you're interested in volunteering, again, email lcemails@acslaw.org. Next Friday at 3 p.m. Eastern, we're also hosting a Pathway to Legal Academia panel. We hope you come and learn what it takes to become a lawyer and whether or not it's something that you might be interested in. We'll talk about what kinds of professorships are available and how does one even become a candidate for them. Again, this will be next Friday at 3 p.m. I will drop the RSVP page in the chat box. And now to the event. So the program will begin with Amy Kepchinsky. She is the professor of law and faculty co-director of the Global Health Justice Partnership and faculty co-director of the Collaboration for Research Integrity and Transparency at Yale Law School. She's also the faculty co-director of the Law and Political Economy Project and the co-founder of the Law and Political Economy blog. Towards the end, you'll also hear commentary from Sabeel Rahman, who's the associate professor of law at Brooklyn Law School and the president of DEMOS, and the faculty co-director of the Law and Political Economy Project. Ganesh Sitaraman You'll also hear from him towards the end. He's a professor of law and ACS faculty advisor and director of the program in law and government at Vanderbilt Law School. He's also on ACS's board of directors and board of academic advisors. Throughout the program, we encourage you to please submit your questions through the Q&A box. So do that throughout the event. Don't wait till the end. And now I will pass the program over to Amy.
Thanks so much, Peggy. And it's a real pleasure to be here with all of you in the always slightly disorienting space of Zoom. I can't see you, but it's wonderful to get to share this time together to talk about law and political economy approaches. So thanks very much to ACS and LPE, those that made this happen, and to Ganesh and Sabeel, who will have some comments toward the end. So what I'm going to do is I'm going to spend the next about 40 minutes trying to talk you through some basic features of law and political economy approaches. What this is really doing is launching a series. And what I'm going to be trying to do is begin us with some basic overview orientations. Why should we study political economy? What do we mean by law and political economy? Why is it essential to center questions of political economy and legal scholarship? And how doing that might help us move beyond neoliberalism to make changes that increase the power of ordinary people, that rein in private power, build public power, and that make our democracy more real. And particularly for those who are most vulnerable today, often people of color, often women who are carrying so much in the midst of this pandemic and who were carrying so much before, right? So we'll have a wonderful set of scholars in the coming weeks. We'll have Angela Harris coming next, and then Jed Purdy. And so please look out for those. We'll put, I think, in the chat links so you can sign up for those. We've designed this as a course with actually the 1L curriculum in mind as one of the reference points, so that we think it'll be particularly useful for those of you who are just new to law school, and hope that you'll come to all of them. There'll be more also in the spring. Okay, so I'm going to share my screen and talk you through what we're going to do today. So, first thing that I want to do is talk about why I'm here. The world is burning around us. So why am I here? I think it's useful to actually say a little bit about how I came to law and political economy and why it matters to me to be here in this virtual room with you all today. The second thing I'm going to talk about is the 20th century synthesis. This is a name that a group of us in a law review article in the Yale Law Journal that include Jed Purdy, David Grewal, and Sabeel Rahman have published in the Yale Law Journal this article that talks about the current state of legal thought, describing it as the 20th century synthesis. So what is mainstream legal thought? How do we understand it right now as related to the many crises that we're living through? How did we get here? So I'm going to try to be sort of specific about the intellectual formations and some of the money and politics that led us to this place, to the 20th century synthesis. And then I'm going to end with where do we go next? And this is the piece that's going to be about how law and political economy scholarship is trying to contest the 20th century synthesis, kind of current conventional wisdom in legal thought and in policy. And that part of the conversation is going to be very much part of what is a work in progress. Building LPE approaches is something that we hope you will do with us. This is not a fully consolidated set of ideas, but a set of approaches that we're building together. And there's a large group of us, as I'll mention, out of the conviction that it's critically and urgently needed to both understand our times and to intervene in them. All right, so how did I come to LPE? So as I started thinking about delivering this talk, and one thing that was on my mind today, I wanted to start with this. This is a series of portraits collected by a really amazing and radical activist group called T1 International, that is a group that advocates on behalf of people with type 1 diabetes. These are all people who died in the last 2 years in the United States because they could not afford their insulin. If you are a type 1 diabetic, you need insulin daily to be able to be healthy, in fact, to be able to survive. And all of these people died for lack of a drug that in fact was invented decades ago. So T1 International is advocating around this. This is where these images come from. They are advocating because the reason these people died is that the price of insulin went up 400% over the last decade. 400%, although nothing had changed about the drug, right? It's the same medicine. So many diabetics are paying $1,000 a month in copays for a medicine that they need to take every day. So people are rationing their insulin. They're unable to take it. We now know in my hometown of New Haven, 1 in 4 diabetics do not take their insulin as prescribed because they cannot afford this. This is an old drug, right? And you can see from the images that T1 put together that the impact here is not equally shared, right? Very disproportionate impact, as is true of diabetes. Generally, there's disproportionate impact on people of color. There's also disproportionate impact here on the poorly insured, right? And who are often, as so many of these people are, young, right? In that period where they fall out of the insurance system, off their parents' insurance, for example. This is an outrage, right? In the richest country in the world, that this should happen, that people should be dying for lack of something that, that could be and was once much more affordable. So how could we be here? How did we get here? So part of what LPE means to me is as a space to ask questions like that. I came in to questions like these health justice issues, having that T1 International is putting on the table through the lens of intellectual property law. In fact, I was an AIDS activist. And what that led me to was to study law because it was intellectual property law and patents that were making these drugs so expensive. So there's a very deep way in which law, and then as I started to reverse engineer, like why is patent law making drugs so expensive? You've got to reverse engineer all the thought that goes into why that's justified and why it's so hard to criticize it from within our existing system. The other thing on my mind today, as I'm sure on all of our minds, is COVID. We are living through an unbelievable kind of catastrophe, and again, that's very disproportionately experienced. So this is a series of articles that I've written recently about this with my colleague Greg Gonzalez, and that try again to sort of set out the stakes of the pandemic from a perspective that centers issues of equity, racial justice, and that talks about how poorly we have been set up to deal with this virus. It's not a problem just of today. It's been many decades in the making. Austerity politics, our policies on incarceration, our limited social infrastructure and welfare infrastructure to support people to socially distance, the idea that the economy matters more than our lives. And part of these, I've been trying to build out proposals about what to do next. And this is very much what you're going to hear me talk about with LPE, both a critique and proposals, how to build in this context toward a politics of care, jobs programs that will help us both better manage the pandemic and build back better. Right? So which is to say, I come here because I care about health justice, and I think our ideas about the economy and how we should structure it, and about political economy matter deeply to the lives of all of the people that we're talking about in health justice circles. Others in LPE enter from different places, and so what this is a community of people. So some people enter into and who are thinking centrally about racism and the way that racial violence and structural inequity shape social order today. So dynamics of hyper-incarceration, of misdemeanor control, of penal welfare, penal debt, right? Others are interested in the widespread sense of precarity and vulnerability in the United States today. We see it with COVID, but we saw it before, right? Income inequality has returned to levels of the Gilded Age, very concentrated forms of corporate power, the degradation of our welfare state, wage stagnation and the crisis of care, where people are working long hours, they're commuting, they don't have control over their working hours, and our ability to just socially reproduce, to take care of one another, is really in crisis. And that was before COVID. Right? Our world is literally burning down around us. If you look to California, right, and the consequences of climate change, you look to Black Lives Matter and the protests against police brutality and structural racism all around this country. And yet our political system and our democracy seem increasingly fragile and hollowed out, incapable of really developing a kind of systematic response. And part of what we in the kind of LPE world are trying to do is connect these crises that we all come to, and in fact, in our own ways, all are trying to intervene in and work on, with the world of legal scholarship and thought, prevailing ideas in legal scholarship and thought that we, in fact, many of ourselves came into when we came into law school. Legal scholarship has been, we would argue, shaped by a misconception concerning the relationship between politics and the economy. So we have this habit of thinking about the economy and political life as separate. And in fact, the economy is sort of more important. This is the markets versus lives story of COVID, right? We have to get the economy back, even if that means sacrificing people, right? The economy is something that has to follow its own rules. We have to free it. And the move to political economy, and this is one way to think about what do we mean by political economy and non-political economy, is the idea that in the insight, drawing here not on rational actor political economy stuff that's done in economics departments, but classical political economy, the way people like Adam Smith or Karl Marx would have talked about it, that the economy is fundamentally political. It's both politically and legally constituted, and it has enormous implications for the possibility of shared democracy. So we center questions of political economy in order to understand them, and also in order to commit to and figure out how to build a more deep, more inclusive democracy, which has to include an economic democracy, to curb concentrated power, build public power, and deal with the deep forms of structural injustice that are affecting so many communities today and our very planet. So part of what the political economy crowd is doing is very much building on the other things you may have heard of in the course of your, whether it's few weeks or few years in law school or legal circles, which is legal realism, critical legal studies, critical race theory. All of these we're drawing upon to kind of try to build this new approach that puts law at the center of our study of political economy. And also, I would say very importantly, and you can see that already in what I've said, to bring conversations about political economy more directly into conversations about structural injustice, race and racism, gender equality, and to do that as a commitment to recentering political economy around those questions, because classical political economy was not about that. So what is LPE, broadly speaking? It's a series of groups. There's a blog, the Law and Political Economy blog. I encourage you to check it out, where lots and lots of people have written. There's something called the Association for Political Economy and Law, APPEAL. That's a group of law faculty. There's the Law and Political Economy Project, with Sabine and I run with some others. There's a journal now. But really what it is a name for work that many people have been doing for many years that connects all of our work through the kind of rubrics that I'm going to describe to you. Okay, so what does the kind of prevailing legal logic or legal framework, mainstream legal thought, have to do with all these crises surrounding us? Why is prevailing legal thought not adequate to deal with all these crises? Well, some of this, I think, will already be evident to those of you who are, even just a few weeks into law school. And this is the kind of phenomenon that we're calling the 20th century synthesis. So 20th century synthesis has, as I'm going to describe it, as we describe it in the Weil J paper, two pillars. They're both deeply shaped by neoclassical economic and neoliberal thinking, and I'll say more about that after describing the kind of legal instantiation of them. So broadly speaking, you get a bunch of fields of law that are often maybe thought of as about the economy, or sometimes people might call them private law. And they get reoriented over the last several decades. This is really a development 70s, 80s, 1990s, right, where it really consolidates. These fields of law get reoriented around the goal of efficiency and wealth maximization. And what gets thrust to the side are questions of coercion or power or justice. So this is contracts and property and antitrust, corporate law, and so forth. And it's a real departure from some of what came before it, from legal realist ideas and others who would have thought differently about these areas of law. So let me talk to you about this imagining that some of you in your first year of law school. So what do I mean? What do we mean by the kind of reorientation in these fields of law towards efficiency? So many of you in torts, for example, will read cases about courts that are grappling with industrial pollution. Factory is built, starts polluting into the air, and then there's the community nearby, and the question is it a nuisance? Right? And the court has to answer this question. What's the right way to answer this question? So you might have come into law school thinking, well, let's ask what's just. Let's think about power. Who has more power? Let's think about history. Why is the factory there? But instead, many people are taught when they get into a torts class, and very, very influential in the legal scholarship is the idea that this question should be answered with reference to something called efficiency. So what's efficiency? That's complicated. I'll say a little bit more about it later. But broadly speaking, let's use markets as a model and put wealth as the value that we really care about. So we put the right in the place, let's say make it a nuisance or make it not a nuisance, that's going to best mimic where the market would put it. That's going to create the most wealth. And that's a very simple example of some of how a question that otherwise might have been discussed as a matter of justice or duty, right, gets talked about through the lens of economics and efficiency. So property, some of you may be taking property. It's a class I've taught. Property is usually where you learn arguments about why property should be private, right? It's almost all people talk about in property is private property and property, in fact, in land. And why should it be private? Well, law and economics completely reorganized the conversation around property in one very, very famous piece where this happens is written by a guy named Harold Demsetz. Harold Demsetz says, why should there be private property? Because you need to internalize the externalities. You want to avoid the tragedy of the commons. When resources get valuable, you have to make private property so that people will internalize the benefits and the costs of their activity. And he tells a story, which is not a true story, but is a very powerful story about a bunch of hunter-gatherers and pelts, and there's beavers involved, and they have to figure out how to create a property system, because that's the only logical outcome of high-value resources, because the only logical thing to do is to order property to make it efficient. And many students are probably learning that and spending more time thinking about that worldview more than they are, for example, learning the history of expropriation upon which all title in this country is based, right? The history, you may read a case, many property law classes begin with Johnson versus McIntosh, that actually marks how conquest is with the foundation of property in America. But you'll spend much more time learning about theories of, how do we get property rules right to make the market efficient, than you will thinking about violent dispossession of indigenous peoples, much less the economics of public goods or other kinds of common forms of property. In contract, again, you'll probably learn, if you haven't already, that that many people in legal scholarship and in the courts are very skeptical of things like unconscionability rules. Well, why would it be bad, you might think, to have a court step in if somebody's being charged an interest rate that's extortionate, that through payday lending or other form? Well, because again, we have to think this through, we have to do the efficient thing, and we have to use economics for our paradigm of how the world works. And that paradigm is, markets are generally efficient, people are rational actors, they're going to bargain, we should let them have the benefits of their bargain, and so forth. This is what I learned in my first semester contracts class. And you might wonder, where did power go? Is that really a good way of describing the world? So this is what's happening on one strut of the 20th century synthesis, is a number of areas of private law are being reorganized through the lens of economics to center efficiency and to put other questions about power and coercion and democracy off the table. Okay, what's the second half? The second half is what's going on in public law. So in these nominally public and political fields like constitutional law, which many students will study in their first year, here, of course, questions of coercion and legitimacy and democracy remain important, but they also get delimited in deference to a kind of an economically oriented, sort of neoclassically oriented way of thinking about what's possible and what's good. So these are areas of law that get denominated by a certain version of formal equality. If you study anti-discrimination law in your constitutional law class, for example, you'll learn about the enormous solicitude given to business under a constitutional as well as statutory theories of discrimination that allow business a sort of necessity exception to anti-discrimination norms. So investigations of power and coercion that do exist in constitutional law seem to stop where the market begins. And you learn that the Constitution is a document that, as much as you might, as an incoming law student, have thought of it as a place where we get to argue about and try to achieve what's just, it has been interpreted and shaped by ideas that make it actually a vehicle to protect entrenched interests, and to argue that we really can't do anything very much, right? There is no there's no scrutiny for class as a classification of the Equal Protection Clause. The way that we think about discrimination is very thin and formal, not deep and historical and capable of reckoning with historical injustices. And in fact, in areas like First Amendment law, you see the Constitution being reworked again over these last several decades, in fact, using some ideas about markets and the free market of ideas, for example, to make, or the idea that money is power, and money is how we have to free up campaign donations if we're going to be able to have a free democracy and be able to have free politics, right? So the very idea that that sort of politics is a market gets assimilated into First Amendment law, which is why we get the campaign finance decisions that we get that strike down democratically chosen campaign finance rules, right? So there's a private side and a public side, but they work together, and we call it a synthesis because there's a common theme, right? The economy on the one hand is sort of receding as a subject in fields that are thought of as political, and the political is receding in subjects that are thought of as economic, right? And fundamentally, there's a similar common theme here. It's about the infiltration of a certain set of economic ideas, a very limited set of economic ideas, particular set of economic ideas, and a commitment to kind of market supremacy, what we might call racial capitalism, at its heart. Okay, so how did we get here then? So all of this is connected, really, these moves that are happening in law, to the kind of legal specification of ascendant ideas in the 1970s, 80s, 90s, and that I and many people writing about law and political economy associate with the term neoliberalism. Okay, so what is neoliberalism? Neoliberalism is typically understood as, well, here, let me give you a definition by David Harvey, one of the influential writers about neoliberalism. So what's neoliberalism? Neoliberalism is in the first instance a theory of political economic practices that proposes that human well-being can best be advanced by liberating individual entrepreneurial freedoms and skills within an institutional framework characterized by strong private property rights, free markets, and free trade. So think Ronald Reagan, Margaret Thatcher, the World Trade Organization, the Washington Consensus, the basic idea here of deregulation to let markets do their work, to prevent politics from interfering with markets, to prevent the state from interfering with markets because markets are efficient. And this is the only neutral and reasonable way to run our affairs. So this idea has a history. There's a really wonderful, rich literature on the history of neoliberalism. We did actually a whole description of it on our Law and Political Economy site. If you're interested, there's a primer on the kind of history of neoliberalism there. Neoliberalism really follows on and is a reaction against things like the New Deal in America, where there was very, very much a different picture of the concentration of wealth and the distribution of wealth and the ability of the state and the openness about the way the state intervened in the economy. It was also a period of relatively low inequality and social mobility. Neoliberalism comes as a reaction to that, also as a reaction, interestingly, on the global scale to decolonization, right? It is very explicitly a set of ideas, although it doesn't describe itself as this, it's very explicitly a set of ideas that are about protecting those who have power in markets from the power of democracies, right? So the ideas are often traced back to the Mont Pelerin Society, people like Hayek and Milton Friedman. And they are instantiated in all of these different areas of our law and policy, far beyond what I've described in my little 20th century synthesis talk. Things like cost-benefit analysis at the heart of the regulatory state, things like the attack on labor unions, cap and trade as a model. You know, one of the kind of archetypal moves of neoliberalism is let's make the government more like a market. So if we have a problem because we have pollution and we have climate change, let's cap and trade. Let's make it more like a market, allow markets to extend further into our collective and individual lives. And note that this is not a left-right split exactly. The Democratic Party moves very much in the same direction, and it's true in Europe too, right? That there's a kind of a movement of, let's say, Tony Blair is the figure that people think of in Britain, even if to not quite the same degree. In fact, this definition that Harvey gives is, I think, you need to amend it a little bit to really understand that what neoliberalism is is not a deregulatory agenda, it's a re-regulatory agenda. It's regulation on behalf of and protection of a certain set of people who are privileged in markets, people who own things, for example, and a protection of them against democratic control or the possibility, for example, of certain kinds of redistribution. So state power is actually built out in this period. I study intellectual property law. You can call it property or you can call it regulation. It's built out extraordinarily in this period. Lots of new intellectual property laws being made, not just nationally, but internationally. Becomes part of a World Trade Organization that is very regulatory, right? All kinds of new laws that are required of states to protect intellectual property. Trade liberalization itself, or investor protection, right? We build out investor protections. Think too about the carceral state. One of the concerns that I sometimes have about the frame of political economy is that people then think we mean and are talking about the economy the way many people think of the economy. And the carceral state, prison's got nothing to do with the economy, right? Neither does the fact that my children are behind a wall here and somebody else is taking care of them right now, right? Care in the home doesn't appear as part of the economy. Part of what is really important to do is to resist those sorts of delimitations and recognize that the economy is shaped very much by the allocation of care, by, for example, the way the carceral state is organized. So, for example, in this same period, the carceral state is built out extravagantly, right? We get immigration laws and immigration, the militarization of immigration, and that is to the benefit of employers, but not really to the benefit of workers, whether documented or undocumented, the way it manifests, right? And similarly, you see Noah Zatz has written wonderfully about this for our blog. The kind of building out of penal welfare systems, or systems that basically give people the choice to get to work or go to jail, say through child support payments, right? Using the carceral state, in fact, to help reinforce market norms is part of what's also happening in this period. Not to mention the way that the building out of the carceral state and the kind of deep white supremacist set of ideas that go along with the way we talk about criminal justice often in this country are useful politically, of course, to people who want to pull together a Republican Party that can get white middle class, working class people to vote for financial barons whose interests are really being represented. All right, so that's one key step. So how do we get here? One is a story about neoliberalism. It's not just a story about ideas, as I'll get to in a moment, but these ideas are moving very powerfully at the time. There's a second set of concepts, which is really the rise of law and economics. Law and economics, of course, is, well, let me just say a little bit more about it and kind of what's going on behind the veil when you see these moves being made in your torts class or in your contracts class. So really what it is the application of neoclassical ideas in economics to law. You model people as rational maximizers. We know our interests and we operate rationally, and we look at everything like a market, including the state. And we argued that law should have an efficient outcome because efficiency is a good or neutral value. And if in any way, this is a very sciencey way of doing things. We have to be rational ourselves, and we have to kind of apply math to politics, because politics is too messy. So some of its key ideas, efficiency is a central value. What does efficiency really mean? I wonder if you hear that word in your classes, and if you do, it might be interesting to ask your professor what they mean by it. And I'll tell you what's meant by it in the literature. My cat, hang on, has to be ejected from the room. This is really a COVID moment. At least it wasn't one of my children. Okay, so efficiency. What does efficiency mean? It means very typically what's called wealth maximization, right? We should do and sort of allocate things with the idea in mind of maximizing the amount of wealth in the world. What's wealth? It's really an idea drawn from economics, the kind of maximization of consumer and producer surplus or willingness to pay, right? So you have to, put the factory where the market will give it the most value, let's say, something like that, right? And you have to do that. Let me just give you another example. So what does wealth maximization mean? Let's say we have to cite a park. And what do? How do we figure out where to put the park? To put it in the rich neighborhood or the poor neighborhood? Well, if we're going to do this, and cost-benefit analysis very much works this way too, by the way. If we're going to do this, what we do is we figure out where there's more willingness to pay. And maybe we look around at who spends more on leisure goods, or maybe who spends more on sports equipment, and that shows that they value that more, and that's where it should go, right? That's one way to understand what wealth maximization is, and described that way, you can see that built into it, there's something kind of unappealing, which I'll say more about in a minute. The other thing about law and economics is that when you maximize efficiency, you're often told, in fact, explicitly, this is part of the theory, that you put distribution to the side. You always think about distribution. Later, somebody else does it. Maybe in the tax system somewhere over there, but we do what's efficient first here, and somebody else does the redistribution, right? And you don't ask about power. You don't ask about history, right? The other thing that really is important in law and economics that happens in this period, and this is very much part of the story of constitutional law I was telling, is that rational choice ideas are applied to government and politics. So politics is no longer a place where we argue about public values, where we debate. It's just interest group competition. And you've probably heard people talk around you about things like rent seeking or capture. Those are all ideas that come out of public choice theory. Public choice theory is the application of economics to politics. And it suggests that all that politics is a place where different interest groups battle. And what that does, of course, is it disappears the very idea that there's something called citizenship, or a public sphere where we actually learn and debate what values we ought to have, and where there is a possibility of people acting in a public interested way, right? So what's the history? How did we get here? We got here through the kind of rise of neoliberalism, and then a very particular intellectual movement, law and economics, which brought a lot of those ideas into law schools. But as I said, as I promised you, this is not just a history of ideas. This is also a history of money. And this is a book that many of you might find interesting if you found anything that I've said interesting so far. It's by Stephen Tellis. It's a book about the rise of the conservative legal movement. And part of what it does is it tracks the relationship between groups like the Federalist Society and originalism as an idea, law and economics as ideas, and a broader political economy, including lots of funding from groups like the Owen Foundation and the Volcker Fund. Some of it actually that's quite connected to Hayek all the way back there, the big Mont Pelerin guy. And so there was very significant funding that went into this, and very deliberate strategies. For example, Pareto and the Pines teaching judges about law and economics, and in ways that there have been some interesting studies, really had an impact on how judges came to see many cases, interestingly, not just cases about antitrust law or business, but also cases about criminal law, for example. So all of this, there's a very deliberate movement building piece of this, and that is part of what constructed the world of law school that many of us entered into, that many of you entered into, although some things may be changing. Okay, so let me talk briefly then about where we go next. Where do we go from here? So I'm going to do this probably too quickly. If you're interested in it, you can read more of the article and come to the next sessions. But where do we go from here? What do LPE critiques kind of look like? Right, I've just described to you the sort of, kind of image that in some sense you probably already knew, that we're supposed to believe in this idea of efficient markets, and the markets are competitive, and they're a kind of neutral way of organizing things. Well, part of what we're trying to argue in LPE is that markets are not natural, right? Markets are constructed by law. And here, legal realists like Robert Hale are really important, right? That you, in fact, can't have a market without law in modern society, and that law does things like allocate entitlements. It creates property systems, it creates contract systems, and that in the design of those systems, or intellectual property, right, we are making public choices. There's no such thing as a market that operates on its own rules. Law constructs markets, and we decide in politics what kind of markets we want. It's really important to be able to contest that idea that we just can't do anything about the market. It just operates according to its own rules. So that's one tenet. Another, that efficiency, this idea that runs through, that seems so benign, like who wouldn't want to do good things, right? That it's actually much more specifically a claim about the value of wealth that in fact isn't neutral. There's nothing neutral about saying that that park should get put in the rich neighborhood and not the poor neighborhood because they'd be willing and able to pay more, right? There's an accession principle, the rich get richer, if that's your definition of efficiency. And so all throughout our law, where efficiency is put at the center, part of what you're doing is in fact deeply connected to questions of equality and inequality. So that's the second move. Another move, politics and economics dynamically constitute each other. Okay, so you can't just say, well, let's first do the efficient thing and put the factory here or put the park here, and then later maybe the tax system will redistribute it, right? Because as you all know as people, that if you distribute something at stage one, that changes who has what kind of power at stage two, including the power to change law, right? And so in the fields that I work, intellectual property, of course, who has intellectual property has an enormous impact on how politics happens and then what rights get defended or cast aside as we move through politics, because politics and economics aren't separate. They in fact interact and they constitute each other. And so if we want equality, if we want democracy, we have to build it into politics and the economy. That's the second stage of that thought. Last piece is a pushback against the kind of neutrality and anti-politics that actually runs through a lot of this same period, right? The idea that we should use something like cost-benefit analysis to rationalize the state, that we should work through public choice theory and learn to kind of rationalize government through technocratic decision-making tools that can kind of manage the economy. The World Trade Organization is a very wonderful example of this, that we were going to manage the economy. We turned out we were managing all kinds of other things at the same time. And those negotiations had to happen inside, behind secret doors, because they had to be done by experts, because we couldn't let interest groups impact them. Well, what if a labor union or an environmentalist shows up? Is that an interest group, or is that like democracy? So democratizing the economy and deepening our democracy is going to require challenging technocratic management tools and ideas. All right, last thing I'll say, and this is where we end the paper, is that we're also suggesting a broad set of critical moves that are moves away from the 20th century synthesis and towards centering something new. So instead of putting efficiency at the center of things, let us put power at the center. Right? Rather than ask what's efficient, ask who has the power to decide, and how do we distribute power more broadly, and particularly empower people who have not had much of it before. And here, there's lots of people in LPE circles that are talking about and thinking about what some are calling non-reformist reforms, right? How do you build power, right? Once you recognize that there's this feedback loop between power and politics and economic power and politics, how do you build power over time? And particularly among those who have been excluded and marginalized over time, and people of color, women, those essential workers out there who are celebrated, but who still can't get the PPE they need, who still don't have sick pay in an ongoing way. Right? Okay, so moving from efficiency to power, and thinking there, we talk about in the paper, that many kinds of power that we might be concerned about. There's constitutive power, where law sets up the terms of a bargain. There's market power. There's a lot of very interesting and important work in economics that shows that, contrary to neoliberal ideas, markets tend to be competitive, that market power is really everywhere in our economy today. It affects the workplace, it affects Amazon, it affects Google, and so forth, right? So markets actually today may be inclined toward market power, and that, if we think that, then we start thinking very different things, whether it's in torts or contracts or antitrust or all kinds of other things, right? And we have to think about the interrelationship between political and economic power. So that's many kinds of power that we should be thinking about and theorizing. We want to move from an ideal of neutrality, the idea that we just should get to the efficient result because that's a neutral way of proceeding. Once you've unmasked that, that's not neutral. What should we replace that with? That's a commitment to equality. We should prioritize equality because, in fact, if we build our institutions and our legal systems around equality, those kinds of priorities will be sticky, right? Distributions are sticky, that if you give people power at time one, they're more likely to be able to protect it at time two. And we're also going to try to think intersectionally and structurally and historically about what it means to build equality here, not a false equality of the kind that you sometimes often get in constitutional law today. Last is a move from anti-politics to democracy. So rejecting the idea that we should think of the government just like a marketplace, rejecting the idea that government can't work. That's really central to the idea of neoliberal technocracy. And the risky bet that we suggest we ought to make on democratic governance and democratic decision-making. The last thing I'll say, and then I'll turn it over to Sabeel and Ganesh, is that all of these ideas, in some sense, also require a lot of not just ideas, but also organizing, connection to movements, and other exercises of bringing power back to those who need it most to make our country genuinely democratic. And so some piece of what we are doing also, when we're not busy teaching courses like this, is thinking about how to put that into practice. So let me stop there. And thanks so much.
Well, thanks so much for that, Amy. That was a terrific presentation, and I think something that everybody found really enlightening. I know I learned a lot from it, as I always do from your lectures, even though we've had so many great conversations over the years about these challenges. I thought what I'd start by doing is answering, asking, and then making some comments on one of the questions, and then Sabeel will take another one of the questions and comment on that, and then we'll throw it back to you, Amy, for a third question and maybe to add some wrap-up thoughts on what we've heard from our questioners. So the first question from an anonymous source in our session here is that one of the purported benefits of a capitalist market based on the neoliberal approach is that it uses the wisdom of a large number of interactions or trades to inform decisions. Economists will often say that prices reflect information from a scale of inputs that would be difficult or impossible to duplicate in a more managed way. So how would a non-market approach to some societal problems effectively approach this information problem? So it's a great question to our anonymous friend. And it's actually one that goes way back in political thought and economic thought, this idea that there's a sort of magic to the market and that lots of different actors coming together will automatically create a kind of wisdom from the crowd that you can't have in an expert because they're all bringing something different to the table. And there's lots of literature in game theory and other things and statistics on when this applies. And it turns out there's a lot of situations in which it doesn't apply. There's a lot of conditions under which this kind of idea, this equilibrium that maybe comes out of pricing ideas, doesn't actually work. And the reason why really gets to what Amy was talking about towards the end of her talk, which is that any allocation in a market is actually based on a pre-existing set of elements that mean that that the decision in the market is actually shaped by these other factors. So this interesting thing, even in pricing, when we think about markets and pricing, there's an assumption in the economic theory model that you have lots of competitive players. But what we actually know is that there's market power in lots of markets. In fact, in all markets, there's market power of some sort or another. And what that means is that you can't say that it's always going to be, or even often going to be, in line with what this kind of broader theoretical approach suggests that has a variety of assumptions built into it. The reality is there's an underlying allocation that is shaped by law, constructed by law, that actually shapes a lot of this. So I think there's a challenge there in thinking about this. One other thing, though, that that's I think really important to think about when we think about societal problems is that you can get a lot of information through democracy also, not just through markets. One of the striking and extraordinary things about participatory systems of government, including democracy, is you can bring together lots of individuals and stakeholders with different perspectives and get lots of information through a political process. And so when political scientists talk about this, they often talk about voice as a way to change behavior, to set rules, and voice is what politics is. It's how we interact with and participate in the political process. And so democracy is actually has these important informational values that you suggested, and can provide them in a more textured and more capacious way than the pricing mechanism in markets, because as Amy talked about, through democracy, we can talk about lots of things like justice, equality, values that we want to achieve, rather than just thinking about efficiency or wealth maximization, which is often what we get when we try to narrow something down just to prices. So that's an initial cut at it. I'm going to turn it over to Sabeel, who will take another question and can also respond to mine.
I see just one thing to add to that, Ganesh, just to link it back to what I was talking about. I mean, I think there's something really appealing about the idea that markets gather information. It's Hayek's brilliant notion, right? But exactly what Ganesh is saying is that what information are they gathering, right? And it's all based on background entitlements, right? So if I give you back to the story of, where do we put how does a market decide what's valuable? The park in the rich neighborhood is going to look more valuable than the park in the poor neighborhood because people have more ability to pay for it, right? So there's a basic sleight of hand at the very core of the kind of the idea that markets kind of match social value. They don't. Legal entitlements decide who has wealth, and then markets tend to serve people who have wealth. And so what you're going to do is all throughout this system, you're going to get decisions made. Think about medicines, right? If somebody lives in a poor country and they can't afford a new TB medicine, well, that's not very valuable. And so we're not going to get it. Well, wait a second. I mean, is that really true? Does it not have social value? Well, it doesn't have market value. There's a lot of social value. What about a problem that's a long time in the future? Like, I don't know, maybe a bad outbreak of a disease, some kind of respiratory illness, right? Well, if it's long in the future, markets don't value it because of discount rates, things like that. They don't value that, right? But we in politics do value it. And we can design systems in healthcare. It's actually what we do. Right? We design systems that say, well, let's try to figure out how to, pay for care in a way that gets people to produce the kind of, interventions that we want. And there's lots of ways we could talk about that in any particular state, context. I could tell you how in medicines, one could replace something that looked democratic or coming from the state, like a prize fund, right? It's what we're doing. The Moderna vaccine that's being tested today is entirely funded by the government, right? We know what we want with a coronavirus vaccine. And in fact, it's a lot of your taxpayer dollars that are paying for it.
Yeah, that's great, Amy, and I think that gives us a segue into a couple of the other questions too. I know time is very short, so I'm actually going to lump together a few different strands here. I'm seeing a couple of questions about what would it look like to bring an LPE or more democratic governance approach when you're thinking about institutions like the WTO or patent law. So I wonder if you could say, those are the questions raised, but I wonder if you could say another sentence or two about where you just last left off of what does it look like insofar as we know at this stage, right, to start to imagine a different kind of political economy, concretely. And then I think we'll have time for one more question after that, but I want to toss it back to you.
Great. So thinking about something like patent law or vaccines, right? I think one of the things that it looks like is, with respect to things like vaccines, ensuring that everybody has access to them, regardless of whether they have to pay, in fact, they should be free, I think, right? I mean, so part of it is sort of, rather than measuring what we want and what should get distributed the way a market does, measure it through some more egalitarian and democratic framework, right? Which is actually, I think, much more politically popular, it turns out, right? People actually really like the idea of a free COVID vaccine. But it's not just that we have to kind of develop the things the way we always have and then make them free at the end. In fact, if we reorganize some of how we think about innovation working, funding public science, right, we might actually also be able to get quicker, better forms of vaccines to begin with, right? And so the work that I do on patent law, some of it is about how too many private property rights can screw up innovation because you have all these conflicts between rights holders and they fight rather than actually innovating, or they game the system and they try to, very much similar to stories that you hear all throughout the kind of antitrust literature where companies are investing huge amounts of money to get some kind of little edge on their competitors, but not in a way that's socially beneficial, right? So we can actually sort of dial down some of those private rights. We can also, dial up certain kinds of public funding and public priority setting. And I guess that's just the beginnings of a kind of answer. In patent law, we can also assert government rights over technologies. I've written about government patent use to say, actually, the government can override patents, and where somebody's holding you up, extorting the American people with the high-priced medicine, you can pay them a royalty. You can go ahead and exert public power and try to contain private power. And those are, I think, two common moves that you'll see. And we could talk about it in another field too.
Yeah, that's great. And I'll just add a quick line here, because I think, some of the other questions too are asking about what does this mean for interpretation of our democratic institutions? And one thing I think, so you've written a lot about, Amy, and I know you have as well, Ganesh, so all three of us have, is the importance of bringing this lens into thinking about the role of law in constructing democratic power, right? And how does law create the space for movements to organize, for legislators to be more reflective and responsive, to kind of remove some of the counter-majoritarian restrictions that, say, a neo-Locke'nerian court might place. And Amy, you mentioned earlier how neoliberalism in the law is a response to response to decolonization and a response to democracy, or a rejection of democracy. It's also, I think, has to be explicitly connected to a defense of white supremacy, right? That I think certainly in the U.S., the neoliberal project arose alongside an attempt to resist desegregation and to sort of encase racial hierarchies alongside those economic hierarchies that you mentioned. I think we have time for one more question. Ganesh, is there one more that you want to just lift up from the list here?
Why don't I take this question, a version of a question, and throw it to you, Sabeel, and then we'll give the last word to Amy. So one of the questions, and it's sort of a theme that comes across in some of these questions, is how do we think of the problem of a legislature not acting in the interests of the people? And Amy talked a little bit about public choice theory and capture, and I think I'll just take a little bit of a gloss on the question, maybe to put it to you, Sabeel, which is a lot of people on the left also talk about capture and the corporate capture of our policymaking process. So how should we think about legislation and the problem of the captured political process through Congress?
Yeah, no, it's a great question. I'll just say very quickly, this is partly why I think an LPE approach to Amy's 3 principles that she talked about, or 4 principles at the end, right? A big part of it is thinking about the legal construction of democratic capacity and democratic power, right? And that's in terms of institutional design, yes, making legislators more accountable and responsive, democratizing the bureaucracy. For example, it's also about how law constructs the ability of democratic social movements to have political power, right? So think about the attacks on labor unions, the ways in which laws around protests have been weaponized specifically to target movement for Black Lives activists in recent weeks and months, right? So we have a whole law that constrains democratic power. But Amy, I want to give you, I know time is dwindling very quickly, so I want to turn it back to you for any last comments or closing words, and appreciating all the questions. Sorry we couldn't get to everybody here.
Yeah, so I appreciate what you said, Sabeel. I mean, the project is immense, right, to sort of rebuild our democracy. And one of the great sort of achievements of neoliberalism, you might say, is making the state more like what it said it was, right? Captured and bureaucratic, and you look at what we were capable of doing with COVID. But it's not because that's what the state can be. That's what you can do. It turns out we fixed the capital markets. How do we do that? Some parts of the state work really, really well, and some people's wishes get very quick responses from the government. So the trick is to try to figure out how to develop reforms that democratically over time are going to entrench power for ordinary people. And I really appreciate there's a question I was just trying to answer while I was typing thick at the same time about how do we do that with a bunch of elite lawyers? Well, I think that part of the story has to be elite lawyers working with movements, elite lawyers seeing that we are just one piece, right? That we can help manifest, kind of more democratic things by being good interpreters of code, right? We can figure out how to say, well, I can figure out how to make that patent public, but that ultimately that this question is not one that's going to be technocratically resolved. We're not going to just, tinker with the code and therefore more democracy. That's not how it works. And so LPE is trying to also hold open a space that is collective and that's being built collectively, students and faculty working together, and that has a fair amount, Sabeel works at Demos, of kind of interaction between people who are building campaigns today and people who are working on some of the ideas that hopefully can help sustain them. And so we very much encourage folks to join in our next sessions, but also help us think about these questions and figure out how to do this work, because it is going to be done by many of us and not by a few pointy-headed creatures like the people on your screen in front of you.
Thanks to everyone for joining us tonight, and thanks to Amy, Sabeel, Peggy, ACS, and everyone at the LPE Project for putting this together. There are 2 links in the chat. If you take a look, you can RSVP for our next 2 events in this same series coming later this month and then next month. They're going to be terrific, just like this one was, and I encourage you all to stick around for the rest of the series over the next couple months. Thanks.